This is part of a series of lunch and learns that we host through Innovate 518, which is a coalition of incubators in the region, funded by NISTAR in New York State. We're happy today to be talking about AI and the law, ultimately how to mitigate your business's risk and working with AI and building AI into your companies. We're really pleased to have two attorneys with us today from Phillips Lytle. We love Phillips Lytle in this area. They're not only in Albany, but they're in Rochester, Buffalo, New York City, amongst other cities. But Phillips Lytle is a business law firm, and we have with us today Anna Mercado Clark, who is a partner and Chief Information Security Officer at Phillips Lytle. As a leader of Phillips Lytle, Anna runs the data privacy and cybersecurity and e-discovery practice teams, and is a co-leader of the firm's cryptocurrency and blockchain team. So she focuses on complex e-discovery and digital forensics, cybersecurity, and data privacy, as well as complex commercial litigation. So as a former ADA, you handle white collar crimes and investigations. Wow. Very impressive. Maria, it goes by Thea.
Thea, yeah.
Davis is an associate at the firm as well, and she focuses her practice on commercial litigation, white collar investigations, and cybersecurity. So quite the duo we have with us. Thank you so much for joining us, and we'll hand it over to you.
Thank you. Thank you for having us. And because we're a small group, we were happy to make this as interactive as you want. We want to cover the topics that you want to talk about today. We're going to keep it light on the law, give you kind of the general landscape, but we're not trying to teach you how to be lawyers today. We're just trying to teach you kind of what to watch out for, what the pitfalls are, when to know to call somebody, a lawyer or some other expert, or how to structure your business to mitigate your risk, as Kelly mentioned. I'll also just mention, we also have an AI team at our law firm as well. Thea and my practice intersect with AI to the extent that there are data security and privacy issues related to AI. We also negotiate contracts on behalf of our clients, both from the perspective of service providers and developers, as well as the customers or the end users on the other side of it. We represent organizations anywhere from high net worth individuals to startups to Fortune 500 companies. It really runs the gamut. And so that's kind of the perspective that we're bringing to the table today. And please interrupt us as we go forward. Kelly was kind enough to send us some questions in advance, so we'll try to address those as well. Good job. Okay, so here's a little bit of an agenda. We're going to level set and talk a little bit about AI. I know you're all technical people, especially if you're at this incubator, but we want to talk about AI from the perspective of how the law defines AI and how the legal industry tends to define AI, because what you might consider AI might not be considered such by the law, or vice versa. We might consider certain things AI that you might not traditionally consider AI if you have a more technical background. We're also going to talk a little bit about what the laws and the rules and regulations look like. 2 years ago, I started getting invited to speak on AI when generative AI was all the rage. And at the time, there were no laws that address AI directly. There were only there was 1 or 2 courts in the United States that promulgated rules regulating how AI might be used in the context of litigation. Since then, in California alone, there are over 70 laws that were considered by the legislature. Over 40 of them have been signed into law by the governor. And that's just kind of in the past 12 months. And so gives you a sense for the pace at which this landscape is evolving, both on the technology side as well as the legal side. And then we're going to talk a little bit about case studies, some of the enforcement actions, some of the litigation that we're seeing in this space, what to watch out for, and looking ahead, what are some of our predictions in terms of what we expect to see. All right, so first let's talk about what is artificial intelligence. And how many of you watch, what is that movie with, that was set in World War II, and I can't remember the name now, but it was an Oscar-nominated film. It was centered around the code breakers, Turing. Yes, Imitation Game. It's interesting because AI is all the rage now. Everyone's talking about it, but AI really as a term was coined in the 1950s. And initially, and if you watch Imitation Game and you're familiar with Turing's work, Turing promulgated a test to determine whether something is AI. And essentially, it's how well can it mimic human reasoning and human function. And so ultimately, that's what it is. When we talk about AI, it's the theory and development of computer programs and algorithms that are designed to mimic natural human language processing and decision making and analysis and even generation of content. Deep learning models, of course, is something that we're hearing a lot about. What's new in the AI space is that in the last couple of years, our computing capabilities have expanded so much so as to be able to mimic better the kind of neural network that exists in our brain. And so because of that, we're able to train algorithms with larger amounts of data. And of course, larger amounts of data are more easily available as well, now that a lot of it is available online. So when we talk about large language models, it is exactly what it sounds like. These are algorithms and models that are trained on large amounts of text data. And the algorithms are trained to perform a wide variety of functions, including text analysis, summarization, sentiment analysis, even generating new content based on the data that it's been trained on. We talk a lot about large language model, but there are also large image models, large audio models. Essentially, all that means is you're replacing the type of data that the model is being trained on based on what type of model it is. And so, Midjourney is one, for example, that's trained on a lot of images and can generate images as well as a result. All right, so what are some of the historical uses of AI? Machine learning is an important one. It's one of the earlier uses of AI. At our law firm, we've been using AI since about 2011, 2012 in the context of litigation. It's what was called technology-assisted review and e-discovery. You might remember in 2016 or so, there was a lot of discussion about Hillary Clinton's emails and how her lawyers were able to produce thousands of emails within a span of a few days. And people said, well, they can't possibly have reviewed all of those emails in that amount of time, and therefore they must have missed something. And really, for those of us who have been using this technology since the early 2010s, we know how they were able to do it, and it's because of technology-assisted review. Ultimately, for machine learning in that context, what the algorithm was doing is learning from the subject matter experts' calls on whether a particular document is the type of document they're looking for. So you tag a document as responsive or not responsive, and then the algorithm amplifies those calls to then push forward to the top of your review or the top of the pile, the documents that it believes you're looking for. And so, after a sampling of a particular data set, you get a sense for how much responsive information you're looking for. And then once the more responsive information is pushed to the forefront of the review, then you're also able to stop the review much sooner because the rest of the documents that you haven't reviewed are less likely to yield the results that you're looking for. So machine learning is basically automated learning by a machine without human intervention. So as you are feeding it data or as you are doing work on the machine or on the algorithm, it's learning from your activities in connection with that kind of task. And so that's what all that machine learning means. Natural language processing is also what it sounds like. It means that it's processing language in the same way that humans do. One of my favorite examples is the word Java. It could mean a type of coffee bean. It could mean a place. It could mean a software. And typically, before we used AI and natural language processing, machines would not be able to tell the difference. They just know that the word is Java. If you say you're looking for Java, it'll spit back out everything that mentions the word Java. Now, even if a particular document doesn't use the word Java, if the machine learning and the natural language processing knows that you're looking for a country in Asia, then it will push back out to you those documents because it knows those are the types of documents that you're looking for. And so that's important because then you're not limited to kind of word searches and using search terms to find the information that you need. Some examples of historical case uses, I already mentioned e-discovery in the context of litigation. Chatbots and virtual assistants also use AI. In law enforcement, actually, I want to say it was in Albany a few years ago when Governor Cuomo was still in office. There was a high school that planned to use facial recognition in their schools to try and identify potentially problematic students before they start trouble. And there, as you can expect, there was a lot of objection to that because, that could lead to adverse consequences to students when they haven't yet done anything necessarily that could be subject to disciplinary action. It's very similar to the Minority Report. I should just do this entire presentation in the context of movies and movie clips. If you haven't seen it, it's a Tom Cruise movie. It's very good. He plays a cop that predicts if somebody's going to commit a crime and then tries to stop people from committing that crime before they commit it. Anyway, so facial recognition, and then a law was passed prohibiting the use of facial recognition in that context until such a time that the legislature can put forward a law that regulates that type of use. And of course, to date, there has been no law that regulates that kind of use. And so we haven't seen facial recognition used in that way in schools. Predictive analytics is another one. There are some jurisdictions in the United States that use predictive analytics. So they have AI train on various social media platforms, and then using social media posts, they can try to predict where they think crime is more likely to occur than other areas. And so some police departments will deploy their resources to those areas in advance of some unrest or activity, criminal activity that's predicted by the algorithm. In the more mundane, everyday sense, predictive analytics can be used in analyzing data. So for financial institutions, healthcare, predictive analytics can be used to predict, for example, whether somebody is going to be a better bet for lending money in the financial context, or predictive analytics can also be useful in determining somebody's prognosis or potential diagnosis or treatment. Workforce optimization is another one. We hear this a lot. We don't think everyone's going to be replaced by robots or AI anytime soon. Everyone has this fear anytime there's new technology that comes online, right? I remember dial-up to connect to the internet, and then we got, high-speed internet. I remember before we had cable and you had the bunny ears and TV antennas. But anytime technology evolves, what we've learned is that there are new opportunities for employment and the need for human intervention in other aspects. And so we expect that to continue as well. We expect efficiency of humans to improve, but not necessarily fully replace. And even if they do replace some functions, there are other functions that the human resources will be freed up to conduct other functions. So that's what we foresee. Data analysis, we already mentioned. Security and risk management is another one. So many enterprises, especially large organizations, actually employ AI to determine whether there are any cybersecurity risks or ongoing incidents in their network. And I'll explain a little bit about how that might occur. Initially, the AI will train on your typical day-to-day activity. It will level set, what kind of activity do you expect to see? How many employees are typically logged on? What type of activity do they do on the network? Where do they log in from? What times do they log in? How much data do they tend to send out? How much data do they tend to ingest or receive? And based on that baseline, if there is some unusual activity that kind of deviates from that expectation, then these AI tools will alert your security team and sometimes even sequester certain potentially problematic files or stop certain types of activities that will not be permitted unless there's some additional approval from your security team that allows it to move forward. So what are some of the case uses now? So in 2023, just for context, the FDA, the Federal Drug Administration, approved 223 AI-enabled medical devices, up from just 6 in 2015. That just shows you the level of integration that we're seeing with AI. And this includes pacemakers, diagnostic tools. In fact, we have represented various medical startups that are designed to assist healthcare providers in conducting their day-to-day business operations and rendering care to patients, and also storing data. But also some of our clients have used the technology to try to better identify potential conflicts among particular medicines or treatments, or also to help kind of narrow the potential diagnosis when there could be other multiple options. How many of you have ridden Waymo or are familiar with Waymo? It's good. We have the adventurous folks on the other end. I actually also wrote it just for the sake of science in San Francisco. So Waymo is an automated, driverless kind of ride-sharing system, kind of like Uber, except there's no physical driver. It's all automated. It's only been deployed in certain cities around the country, San Francisco being one of them, Austin, in Arizona also there's a city, and there are a few others. And as a side note, there is a university that's actually conducting a study to figure out how much data, how much bad data does it take to interfere with the large language or large image training, including for Waymo, and they found that it doesn't take a lot. And in fact, so Waymo is trained to recognize certain street signs based on the shape, based on the color, based on whatever letters might appear on it. And this university fed a similar, I shouldn't say Waymo, fed a similar algorithm images that were designed to teach them that those are stop signs and they're not actually stop signs, and found that the algorithm actually changed the way they interacted with those signs quite rapidly with only kind of a very minimal data set. So it just tells you that, you know, the large language models are good in that you are able to really train these algorithms to give you output that you need, but also because of the rapid development of these algorithms as you feed it information, and because it learns continuously from the data that you input, that it could also skew those results. So you have to be really careful about what data you're inputting. Also for context, as of April of 2025, Waymo has undergone or has delivered 250,000 paid rides a week. That's kind of their average now. In August of 2024, just a year prior, they were averaging 100,000 rides per week. So we're seeing increased adoption. In February of 2025, they were at 200. So it shows you that there is kind of a really significant and rapid rise. Apollo Go is a very similar service that is largely available in China and other parts of Asia, Abu Dhabi, Dubai, and they are actually at 14 million rides total as of August 2025. So there's even larger adoption outside of the United States. You'll see also on this slide some studies showing that optimism about AI is growing. So you're seeing that there are more people who are less afraid of AI and kind of welcome integration of AI into products. So if you're thinking of developing products, I think you're going to see kind of a lower resistance at this point. In part, I think because it's so ubiquitous and we're seeing it and we're getting used to seeing it in almost all the products that we encounter. So I also teach at Fordham Law, and one of the things that I am now realizing is some of my students, some of the younger folks, don't even realize that there's an AI component to certain of the products that they use because they're just so used to it, and this is just what they know. And so if you are developing, if you have a workforce, one of the things you should be thinking about is training your workforce to know what consists of AI, what doesn't consist of AI, and also what they're allowed to use and what they're not allowed to use, and have those ongoing dialogue and discussions with them, even as the landscape changes. Because it's very hard to regulate when people don't even realize that what you seek to regulate are the things that they're using every day. Next slide.
So now we go to the legal landscape. We see here an overview of the countries that have already enacted AI laws and policy frameworks. Among the jurisdictions in focus would be the United States. And the countries in red are those that are leading in AI legislation. The common themes of AI legislation around the world would be, number one, risk-based mitigation, whereby policymakers would classify AI system based on risk, and depending on the risk factor, there would be stricter requirements for the AI system or the developer. The next would be transparency. We see policymakers requiring developers to explain their algorithms and document training data. Third would be human oversight, wherein policymakers still feel the need of human review and redress mechanisms to ensure that automated decision-making is not discriminatory. Lastly, everyone seems to have consistency or no regulatory fragmentation across all jurisdictions to ensure that if an AI system is used in one country, it would be allowed in another country without much hindrance to AI innovation. So
just one note is where you are seeing kind of the color coding and where there's regulation, it doesn't necessarily mean that there's one overarching regulation that exists in that jurisdiction. For example, in the United States, there's no federal law, but we do have pockets and many different legislation that could overlap to kind of create that patchwork.
Yeah. So from there, we see that in the United States, as Anna mentioned, there's no comprehensive federal AI regulation or law that would encompass like the whole country. But states like California, Utah, Colorado, and Texas have signed into laws state level regulation of AI. Before we see that state legislators would enact laws that would create bodies for AI oversight. But now we see that laws are AI system regulation is embedded into consumer protection and consumer protection laws and commercial laws. So first we discussed the Colorado AI Act. This will be in effect June 1, 2026. So the law guards against AI or algorithmic discrimination. What does this mean? It means you differentiate between your treatment between persons or classes based on a use of AI. It classifies also, as I mentioned earlier, certain AI systems as high risk. So high risk would be use of AI for automated decision-making that materially affects a person's legal rights and obligations, like in education, employment, housing, credit lending, etc. So to protect against these possible AI discriminatory acts, the law requires developers certain disclosures to a deployer. What is a deployer? It's a business or a user of that AI system in their everyday business, right? Developers are required to make a high-level general summary of their AI system, what their training data is, and the likelihood that it would cause discrimination when used. And they are also required to report to the state attorney general if the deployer is, if they think that the deployer is using their system in a discriminatory way. The deployers, on the other hand, are supposed to inform the end users of their products why they were denied of a certain service or a benefit for using the AI system. Not only that, there's also required to tell the end user how much of that decision making was based on an AI algorithm. The next would be the Texas Responsible AI Governance Act. Instead of focusing on AI discrimination, algorithmic discrimination, it focuses on the ethical use of AI and polices developers and deployers from using AI for prohibited activities. Among the prohibited activities would be what you see on the screen: infringement of constitutional rights, that's self-explanatory; behavioral manipulation, or the use of AI through the use of AI by encouraging someone to physically harm oneself, another person, or commit a criminal act; the creation and distribution of child pornography or deepfakes, that's self-explanatory, and they also guard against discrimination. The Texas Responsible AI Act requires the Department of Information and Resources to establish a regulatory sandbox program. So what this does is it invites developers to apply their AI system for testing under this program, and then during the testing period, which is 36 months, they are immune from any suit from the Attorney General for any violation of the TRIGA, the Texas Responsible AI Governance Act. So, however, even if they're immune from suit from any violation, they're still not allowed to develop or deploy AI systems for the reasons that you see above, the prohibited uses of AI.
I'll just add, this is a lot of these requirements and the way that it's structured is very similar to the EU AI Act.
Yes.
And I know some of you have asked us questions about that. So the EU AI Act is interesting because unlike the US laws that are very internal focused, right? So for example, the Colorado AI Act requires bias mitigation, certain audit requirements. It also requires that developers retain certain compliance records to be able to prove, if asked, that they are complying with the law, but it doesn't actually require any external reporting. So unlike in the EU, where there is some more oversight, so what would tend to happen is these issues would only come to light if there is a person who complains that they've been the subject of a discriminatory practice through the use of AI. And that's what we typically see in the United States, is these things are uncovered through litigation. That's a good question. So it's interesting because the AI Acts or the AI laws generally apply to businesses that are conducting business in these states, which is unlike the data security and privacy laws, which might also apply to AI developers, right? And those laws have extraterritorial reach, meaning they seek to apply to companies even if they're not physically located or doing business in a particular state, especially if there is an impact to their residents within that state that the regulation is effective in. Different organizations take different approaches to compliance when it comes to AI, data privacy, data security. Some of them will say, you know what, let's take the most restrictive approach. And whatever the most restrictive law is, let's comply with that and let's run that across the board and apply it across the board. That is typically what we see the larger the company is, because that's easier for them to actually enforce. For that same reason, there's actually been a lobby by tech companies to have a unified federal law on data protection, in part because it's actually really costly and really difficult for these large companies to have to comply with not only state-specific laws, but industry-specific laws, and also federal laws versus state laws, and then the different regulatory agencies have their own rules. So the FTC, the SEC, the EOC, all have their own regulations as well. So that's one approach. Another approach, as you mentioned, might be modifying the way that their services are deployed in particular jurisdictions. Here, the good news about these regulations is, for the most part, it's consistent, right? The different high-risk AI systems that are listed might be different. For example, one lists constitutional rights, the other does not. But ultimately, the goal of the laws are the same, and the spirit of the laws are the same. And so even if you're not keying your AI development to one of these laws, if you are sensitive to bias issues and issues that might impact an individual's fundamental rights or freedoms, then that should also be sufficient.
So for the sandbox, the DIR would have allowed only 36 months of protection for that, right? It could be extended for good cause.
Yep.
However, the protection against suit by the AG would not extend beyond their time in the sandbox. So if their period would be 36 months, then the protection would only be 36 months. And if they still continue testing their product not within the program, then that would not be protected anymore. They will not be protected from suit.
The other thing is the program requires periodic reporting to the Department of Information Resources about the progress, about what's happening with the product. And so it's not as if there's no oversight during this period. So, you know, when Thea mentions that there has to be a good cause for an extension, that's kind of real-time management, as opposed to just being able to claim at the end of the 36 months that, you know, we're still in testing phase and therefore we need additional time. The other thing is, you know, the immunity is limited, right? It's immunity against enforcement actions by the AG in connection with the AI law. Doesn't immunize the company from other lawsuits or other enforcement actions for violating whatever the deployment might be. And so, you know, there's not that much incentive really either to stay, not as much incentive to stay within the sandbox program, which can be restrictive, right? As opposed to just deploying the product more broadly. It's going to take effect in January 1 of 2026.
Okay.
But because of that, you should, if you're interested in it, you should start looking into the application process, because that's going to inevitably take time. And depending on how many companies seek participation, they might cap it at some point, just practically speaking, especially because of the ongoing kind of management component of it. So the text of the law does kind of, sandboxes, I know we think about sandbox as an actual, sometimes physical storage area, but in this context, all that it means is it's kind of a protected area, protected against potential enforcement of the law. It doesn't mean much more than that, really. And I suspect that depending on what type of product, if they see something in your reporting that they find to be particularly interesting or potentially problematic, they might ask you additional questions. And then, of course, you might have some proprietary or intellectual property concerns. And if you choose not to answer those questions, what will likely happen is you get kicked out of the sandbox program. And then, you're similarly positioned as other companies that are not in the program. We wouldn't know at this point because the law it's a relatively new law. It hasn't yet taken into effect, and we don't have insight into the process because it's kind of very regulated and run by the government. I suspect there will be studies and they'll likely issue some kind of reporting about that, but I don't expect that to happen for at least a year after this goes into effect, just because their priority is going to be getting the program up and running. And that's partly why some of these laws have such lead time before it comes into effect, because there's so much work that needs to go into it before it can be enforced. For example, the Colorado AI Act was supposed to take effect in February of 2026. Because of pushback from the industry, because of the expense and the amount of effort it would take to get companies ready for compliance, that was pushed back to June of next year. It remains to be seen whether it's going to push back even more, which has happened in the past with other laws. So here are some additional laws that we wanted to mention to you. The California Transparency and Frontier Act. Really, these are geared towards large kind of developers, and the guidelines are very similar to what we're seeing in the other laws, which is they want to establish certain base level regulations to minimize potential harm and potential risk to consumers. California is at the forefront of a lot of the technology related legislation that we've been seeing since about 2020, when they passed CCPA, which is the California Consumer Privacy Act. And we continue to see that in connection with AI. So here you'll see there's a transparency report that's required. Of course, given the trade secrets and intellectual property considerations, there are certain redactions that are permitted and expected. There's also, interestingly, a protection for whistleblowers, possibly employees or other individuals who might have information about certain AI systems that are being developed that protect them from certain prosecution if they blow the whistle about a practice that is either against the law or potentially harmful to consumers or problematic for some other reason. You'll see at the bottom of the slide, we also kind of summarize for you the different buckets of the laws that we're seeing promulgate around the country. I mentioned earlier at the very outset that there were only about 2 courts around the country that regulated the use of AI specifically in connection with litigation. Since then, we've seen almost every state has at least one jurisdiction that has some AI regulation. And also the ABA last year put out a formal ethics opinion to provide guidance to lawyers as to how they should be using AI, what level of transparency is required. So if you hire lawyers, there is a certain level of transparency that they're required to provide to you if they're using AI to provide services. There's also a limitation as to how much in legal expenses they can charge a client. So for example, if AI is making legal work much more efficient and something that would take 3 hours now takes 5 minutes, they can't charge for the 3 hours. They are only permitted to charge for the 5 minutes it actually takes to do the work. There's also, in terms of transparency, certain disclosures. If the lawyer is making certain material decisions based on information that they receive through AI or based on the use of AI, they must disclose that to their clients as well. And they must disclose that their decision-making or their guidance has been significantly informed by that AI to allow the consumer or the client to make a determination as to how much weight to give the lawyer's advice, but also to allow the client to let the attorney know perhaps they don't want the use of AI in connection with this particular guidance. They want the lawyer to conduct some more manual analysis and provide advice based on that, or at least check to see if those comport with one another. So that is the ethical and professional obligation of lawyers. So it's not it's not technically law because there's no statute that says it, but it is the expectation. And so if there is, if a lawyer does not do that, then a client can lodge a complaint, usually with the State Bar Association or the State Bar, so that they can initiate disciplinary action against the lawyer. That can lead to disbarment or fines or a disgorgement of the fees that the client has paid to the lawyer. And different industries are regulated by different agencies in the United States. For example, and we'll give you some examples of this later, if you have more than 15 employees, you could be subject to the EEOC, which is a federal employment agency that puts forth guidance as to how you're supposed to treat your employees, what you're permitted to require them to use in terms of AI. If you are engaged in interstate commerce, the Federal Trade Commission can regulate you. There are certain exceptions. Banks, common carriers for communication, transportation, not-for-profits are exempted from the Federal Trade Commission enforcement. But most companies in the United States are subject to enforcement by the FTC. If you offer stocks or bonds or similar products, you might be subject to the SEC, which is the Securities Exchange and Exchange Commission. If you are conducting business in a particular state or providing services or marketing to individuals in a particular state, you might also be subject to those state laws. And as an example, in New York, in addition to state level laws, for example, the General Obligations Law governs all companies that do business in New York. If you are conducting business in a particular sector, you might also be subject to additional regulations at the state or local level based on the type of industry that you're in. So there's an educational law in New York. There are, if you're a government contractor, there are additional regulations. So there's no one entity, unfortunately, and there's no one law, which is what makes it so challenging. It really depends largely on what is your geographic footprint. Where do you conduct business? Where are you licensed? Where do you pay taxes? Where are your employees located? It also depends on where you are marketing and where the impact of your services might be. And then also it might depend on what industry you're in. Those are kind of the big buckets if you're thinking about who you're going to be regulated by. In terms of some of the other laws and amendments to laws, we're also seeing an amendment to laws that define the word person to clarify that AI generated personalities and work product are not considered persons for purposes of criminal and civil laws across the United States. That not all jurisdictions have done this yet, but many jurisdictions are doing it. It's kind of a low-hanging fruit for many of these states. If they're going to pass an AI law, this is an easy one. Everyone can agree on it. They don't really need to even understand AI to agree that it's probably not a good idea to say, if you're not a natural person, you don't qualify as an individual under the law. It's interesting because there's so many laws, and I just did this recently on another case. There's so many laws that don't actually bother to say that when we say individual, we mean natural person. As opposed to a company, as opposed to a not-for-profit entity, as opposed to, kind of a computer-generated thing. And so I think the law is scrambling now to bridge that gap between technology and the reality and what the language of the laws are. Another bucket of laws requires certain disclosure if you're using AI. We saw this a lot during the lead up to the last general election, last national election. So many jurisdictions actually don't prohibit the use of AI to create deepfakes, particularly in connection with, election advertisements. What they do, however, is they regulate the notices and the disclosures that are required in connection with generating that type of content. So oftentimes there will be a restriction on, you have to say in a very visible way that this is fake, that this has been generated using AI. There are also restrictions as to when you can deploy those types of advertisements relative to when the elections are taking place. Because of course, if something is so, people might not appreciate that something is AI generated, even if you have disclosures. and the laws are trying to guard against potentially adversely impacting elections as a result of deepfakes that are being conducted. In terms of deepfakes, we're also seeing regulations related to child pornography and revenge pornography. And so restrictions on using real life persons' likeness in connection with generating videos or photos that might show those individuals in compromising sexual positions. It's also interesting because the definition of pornography in some jurisdictions are now being modified to say even if something is not real, even if a child pornography is generated by AI and it's not it's not a real child that's involved in the video, it's still a crime. So again, we're seeing kind of a variety of reactions to how AI is being used, which is very interesting. In some states, they're creating laws to allocate funding to the development of AI. They're also creating think tanks and regulatory agencies or even exploratory commissions at the government level to investigate how AI can be used, how it can be regulated, or how it can be deployed within the government itself. And then last but not the least, courts expressly require certain certifications and disclosures and record keeping when they're using AI in connection with any filings with the court. And we're seeing a lot of this. There are now well-documented cases of lawyers using and citing cases that are not real cases because they've been generated by AI. In fact, there was just this summer, there was a district court judge in New Jersey that put out a decision, presumably prepared by one of their law clerks, fresh out of law school, that cited the wrong facts, cited non-existent law, and the judge and ultimately the litigants in that case, the lawyers basically said, Judge, we don't know, this seems to be wrong. And the court pulled that decision, didn't actually say it was because of AI, but everyone thinks it's AI. They also didn't disclose which law clerk was involved in drafting that decision. And so it's interesting, right? Because I think they're seeking to protect that clerk, but now all the clerks that work for that judge during this time period are going to be tainted with this kind of AI situation. And it puts the judge at a difficult position because they're the ones who are usually enforcing these regulations and telling lawyers they should not be using AI without manual confirmation that what the AI is putting out is actually accurate information. And so it's tough when at the same time you're also now you've fallen victim to this. Okay, so some of this we already touched on. So we just wanted to give you a smattering of some of the federal agencies that are regulating the use of AI, and we'll go through some examples, but these are some of the agencies that you might encounter. One that I didn't mention is the Department of Transportation. And so, they are regulating testing and verification and auditing of AI that's used in transportation systems. So if you're providing services to any transportation companies, something to take a look at. That's a really good question. And actually, at the end of Biden's term, there was HHS, which is the Health and Human Services that enforces HIPAA, put out a guidance saying they're going to increase their enforcement action against companies that are developing and using AI, particularly in medical devices and medical products. And so even though the FDA is not the one that's putting out that statement, that has now been confirmed and reiterated by the Trump administration as recently as, I want to say July or August of this year. And they've said that they're going to seek enforcement. The distinction is the Biden administration was focused on the deployment of these devices and kind of products in the healthcare space. And the Trump administration has not made that distinction. They're just saying any use of AI within the healthcare industry is going to be looked at more closely. And which is interesting because in every other area of enforcement, this administration has kind of taken a position that they're not going to do much enforcement. So this really stands out. It remains to be seen what they do with that announcement, but it is noteworthy that they kind of put that position out there. So at least they're telling the world that they're going to enforce. Sure. All right, so some examples of notable case studies. So in 2024, the FTC, the Federal Trade Commission, basically made an announcement that they're going to deploy Operation AI Comply. And by that, they meant that they were going to pursue enforcement actions against certain AI companies or companies that are deploying or developing AI. Again, the FTC governs interstate commerce, and really almost all types of companies are going to be subject to FTC regulation, especially if they are consumer facing. The only exceptions are, the transportation, common carriers for communication, not-for-profits, and certain financial institutions. So in this case, Do Not Pay was an online subscription service. They claim that they have the world's first robot lawyer. And by the way, the regulation that we're seeing from the FTC is largely what's called AI washing. It's against AI washing. It's actually making claims that your product can do so many different things, but not having the data or the testing to back up those claims. Because at the end of the day, the FTC is concerned about deceptive and unfair practices targeted at consumers. And so in January of this year, they settled enforcement action against Do Not Pay. They said, first robot lawyer. When the FTC asked them to prove this claim, they determined that this company did not hire any lawyers to conduct any testing. They didn't actually compare whether their product performed better or equal to a human lawyer. And so as a result of that, they agreed to pay $193,000. They also agreed to notify consumers between the years 2021 and 2023 that there was this enforcement action, and that $193 is actually being distributed to the people who purchased the product. In March of 2025, the FTC also announced a $17 million settlement with an online cash advance company called Clio AI, finding that Clio AI misrepresented how much money consumers can get as a result of getting their service, and also when they can get that money. And apparently there were small businesses in particular were targeted, and they lost something to the tune of $250,000 per business, and in some instances went into debt because they were paying for the subscription service. And so the FTC is really concerned about how these AI companies are treating or perhaps duping their consumers. Just in September of this year, there were 7 companies that the FTC wrote to asking for more information about how their AI products are interacting with children. Some of the usual suspects were included: Meta, Instagram, Snap, Alphabet, which is Google, but there's one actually that's called Character AI. And apparently this is a service that was downloaded over 10 million times in just for as long as it's been in existence. And a lot of the users are children, and the children interact with characters that are generated by this product as if they are friends. There's actually a lawsuit that's going on right now because there was a 15-year-old girl who committed suicide as a result of kind of going down this rabbit hole of having a friend called Hero that was generated by this AI product. She stopped talking to any other person and only talked to this AI bot. She was a National Honor Society student. She was engaged with her community, and then she became withdrawn, started talking to the AI about her suicidal ideations. And the claim in the lawsuit, it was just filed this year, was that the AI and the algorithm kind of pushed her further down this rabbit hole, as opposed to kind of pushing her to seek help or talk to outside people and other options.
So in this next case, Workado is an AI content detector, and it claimed that its tool could distinguish between human-generated content from AI-generated content with 98% accuracy. But when the FTC further investigated, it was found that this 98% accuracy only applied to academic content. And when they tested this against non-academic general purpose content, the accuracy rate was only 53%. So the FTC issued an order basically saying that similar to what the FTC did in previous cases, they were supposed to inform their consumers that of the accuracy rating. They're not supposed to market their products claiming that they have this accuracy rate when it's not substantiated. They're supposed to keep records of all the testing they've done to prove accuracy rates. And this order is good for 20 years, and every violation of this order maybe impose a fine of $50,000 per violation of this order, good for 20 years. And the next case is about Air AI. So Air AI was selling coaching and marketing for small and medium scale businesses. So apart from this marketing and coaching products, they also sold an AI access card. So this AI access card had a conversational AI product, which they're saying could replace your customer service representative. You will gain millions of dollars and thousands of dollars within a month. And if you resell this conversational AI, you will also recoup your investment, etc. And it was found that instead of recouping investments and getting profits, these small and medium scale businesses lost around $19 million and thousands of dollars every month. And this case is actually still ongoing before the District Court of Arizona. So this is, I think, one of the first cases that they actually filed, FTC filed in court. Right, so these are copyright infringement cases for training data used to train Claude LLM by Anthropic AI. So for this first case, there are two types of training data here: legitimate sources from books and pirated books downloaded from the internet. The court found that it was fair use it was protected under fair use doctrine to get legitimate sources, and these legitimate sources be used to train data. However, for the pirated sources, the court found that they should go to trial to determine whether or not there was copyright infringement. However, the case was settled for $1.5 billion. So we don't know yet if training data using pirated sources would be protected or it would be considered copyright infringement.
I think the point of this in the next slide is really that you're seeing a lot of intellectual property disputes based on the training data. We don't yet know what the courts are going to ultimately say about this data, because the way that the intellectual property laws in the United States is structured is that the laws try to protect the investment of the original author and the original creator of the work, so that you can encourage those people to continue creating, while at the same time not stifle the creativity and other people being able to build upon that work. And so there's a balancing act there. And so what the courts will decide will probably depend on how the work is being used, whether it's transformative enough to say that this is not just stealing and using somebody else's work outright, whether they're actually doing something to improve it or change it or otherwise modify it.
Can I just add one more thing
Sure.
about that? There seems to be no problem with training data, but when the courts were really concerned about the output that the AI systems would generate, that would constitute copyright infringement. And as for the trademark, from a while ago, there was a confusion. There was really a issue of user confusion or computer confusion. If there's a computer that's confused about the marks or the output of the AI systems, then that was not really taken into consideration in the court's order in determining whether or not there's trade name or trademark infringement. It was really about the end user confusion, not the computer confusion.
Okay, so I will just show you this video if it works, which is an example of a deep fake.
Українці, шановні захисники, президентом виявилося не так вже й легко.
So I'll just stop. You don't need to see the whole thing, but it kind of shows you that the level of sophistication of the AI generated images and videos have just significantly improved over time. And there's so many more examples. In fact, leading up to the election, there was a robocall that sounded like Joe Biden telling people to stay home and not vote.
During the primaries.
Yep, during the primaries. So that's another example. And then why don't we answer some of the questions that you sent over? So the first one is, do we believe that the United States should have regulations similar to the European Union's AI Act? I think we already have a lot of laws that mimic or mirror the regulations in the European AI Act. It's a challenge in the United States to pass anything federally, especially given kind of where the politics are of this country, but also given the level of sophistication of our legislators. Unfortunately, they're not all familiar. If you listen in on any of the hearings, and they're publicly available, you will realize just how large a gap there is between the people who are making the laws and the information and the knowledge about the underlying technology that would allow them to effectively be able to generate legislation. What approach or tools or current compliance methods used to detect bias or regulatory challenges? Interestingly, the laws that require bias audits don't even have a particular method by which they're required to do that. Some of the laws will say you need to use a third party to conduct a bias. And typically what they do is they look at the input and they have a human conduct a similar analysis. And then they look at the output and see whether the rate at which the AI generated output is commensurate with what you would expect in kind of a traditional process. They would also take a look. There was actually a lawsuit because there was a company that was using AI for employment purposes, and they noticed that women above the age of 55 and men above the age of 60 were not getting job offers. There was a lawsuit by a person who was denied a job because they resubmitted their application using a different date of birth, and they got an interview request. And so, you know, just kind of looking at what type of data you're collecting could be a good way to minimize some of the risk. So for example, that company decided to stop asking for date of birth because it's really not relevant for the most part for the functions that they were seeking to fill. And it was just creating risk for them. With AI disruption, how do the above tools and approaches evolve? I mean, it's evolving, the laws are evolving and the technologies are evolving at the same time. And so it's kind of very rapid is the pace. And it's in some ways it can be haphazard, but I think we're seeing a normalization of certain components and that happens with the laws, right? Some states will go first and then you'll see that many of the same themes are mimicked in other jurisdictions. So the next question is, would it be good to confirm the accuracy of AI generated business risk analyses by industry and business function? Always a good idea to test the output of your AI product or systems. Even if you're not able to do that every single time, because then what's the point of using AI? It's good to conduct testing, periodic testing, both of the output, but also the algorithm itself, because of course it's learning as it goes, and to conduct at least once annually a third-party assessment. Have real-time AI fact-checking of politicians' speeches and refine laws to hold them more accountable if they lie. The problem with the word lie is that that's not technically regulated, right? False statements made to the government are regulated. If you fill out a form and you say something that's incorrect or untruthful, then you could be prosecuted for that. But otherwise, puffery and saying things in the public space is not generally regulated. It could be by the Federal Trade Commission, but they don't regulate elections. So that this is a tougher proposition, especially because many of the politicians' statements can be perceived as puffery and framing and characterization as opposed to actual factual statements. But there are companies that are using kind of AI to analyze these statements in real time that helps with their reporting. So I think there are ways that we can use technology, but just perhaps not in this very direct way that is contemplated by this question. Using AI to review legislation and actions for violations, current statutes and legal precedent in order to mitigate court backlogs. Courts, actually, there are already AI technologies that are in use, not by courts and by lawyers.
Mm-hmm.
So in connection with our litigation guidance, we actually conduct an analysis of a particular court or particular jurisdictions, particular decision-making on some issues and certain timeframes to better predict what a potential outcome might be. But it's not a guarantee because, as you know, courts can be mercurial, juries can be mercurial, and so you can't really guarantee potential result. That's a good question. So just because something is AI doesn't mean that the other regulations that apply to educational institutions no longer apply. So FERPA still applies, state laws still apply. And so the things that you would do to comply just is modified based on the type of technology and workflow, but ultimately those laws still apply. The workflow that you describe is a good one. There are a few other mitigation strategies: minimizing the data that you collect to only what's absolutely necessary, deleting data in a more timely manner. Also, it's a little bit harder for educational institutions, I understand, but really think about, for example, medical records from 30 years ago. Do you really need those? Also think about the sources of your data, because if the medical information is something that you receive from a covered institution, that could be subject to HIPAA, even though technically medical information that's generated at your own clinics, et cetera, might not be subject to HIPAA because it's already subject to FERPA. So thinking about what are some of the regulations that might apply based on where you receive it, based on who you give it to, might be a good one. And also anonymizing the data where you can, truly anonymizing the data, or bucketing the data if you can't anonymize sufficiently the individual data, and saying, here's the data for this group of people from ages so-and-so, or from grade so-and-so, or majoring in whatever. Having contracts and kind of enterprise specific solutions is another one, in addition or instead of saving things on your own server. Making sure that when you enter into agreements, that whoever is receiving your data is limited in how they can use that data, how they can disseminate it, and what protections they have to employ in order to protect that information, and how long they can keep it. That kind of thing is another thing that that we're seeing. And then the last piece is there are some offline LLMs. So there are some solutions that are not even connected to, the internet. Yeah, so if there is a lawsuit, typically information that is relevant to the claims or defenses in that lawsuit are subject to a legal hold. So even if they could be deleted because there's no other legal requirement requiring them to be retained, as long as the litigation has not yet concluded, there would be an obligation for the organization to hold on to that data, which is why we counsel companies to delete data as quickly as they can before you get served a subpoena, before you get sued. And as soon as a lawsuit is done, you want to delete all that stuff, because lawsuits typically beget other lawsuits. The other thing is, even if you delete your chat history, the model has been trained on it. And so you don't know when that's going to be spit back out to you. So for example, for lawyers, right, at our law firm, sometimes we have confidentiality walls where Thea might represent a client that is adverse to my client, but the clients have agreed to waive the conflict. And, some people might say, well, okay, we'll protect the data. Thea can't see the files for this particular client, and we won't talk to each other about the case. The problem is, if we use even an enterprise solution, we input data, that data has now been ingested. If I say, for example, company A had X amount in revenue over the last few years. Now, if they ask the question, how much in revenue do you expect this company to have in future years, or how much revenue have they had in prior years, the input that I had put in there is now going to be visible to Thea, even though she's not permitted technically to have the information. So the other thing I'd say, if you're an educational institution, is think about who has access to the system, and are they permitted to see all the information that you're training? Because you can also tune an LLM model as opposed to fully training it. You can tune it to just do specific functions. And so that's another option as well. There's no way to do that.
Okay.
There are some ways to do that if you have an enterprise solution where you can say you're not allowed to train the model and use that trained model for other deployments. You can do that. And that might be the best way. But at the end of the day, once you input data into a model, if that model is accessible to anybody else, there's always a risk. Not always. You can try, but there's no guarantee. And sometimes masking doesn't work because then it doesn't give you the output that you're looking for. That's the challenge. There was a study where there was, what do you call this? A census. And so you told people, how many people in your household, what the ages are, et cetera. And there were a group of researchers that took that publicly available census information and were able to match to a person who that data belonged to, which is kind of remarkable. Yeah.
Yeah.
That's why we know so much about it, because we do work with a lot of startups and different size organizations.
Yeah, thank you to Anna and Thea from Phillips Lab.
Thank you. Thanks for having us.